Okay. Let's see, we were still in the... Yes, right. We're still in Mr. Elking's cross-examination, I believe. You may inquire, Counselor.
Thank you, Your Honor. No further questions.
Any redirect?
No, I actually redirect. I would like to indulge you to allow me to introduce some exhibits and evidence. These are the ones we talked about.
You may.
So
Just go ahead and introduce.
Thank you. First is Exhibit 59, Your Honor. It was a photo of the front of the house. Second one is Exhibit 61, a photo of the answering machine that Mr. Elking left at Mr. Boyd's house.
I wondered what that was.
Remember, we had, I think we substituted.
Yeah, I saw it. I just wasn't sure what that was in that bag. Go ahead.
Exhibit 46, which is one of the lineup pictures. Exhibit 47, which is one of the lineup pictures. Exhibit 10, which is the letter from Bromwell, and then the letter from Elking, to whom it may concern. Exhibit 11 is a letter from Mr. Elking, dated 11/24/03. Exhibit 11. Exhibit 33. Exhibit 34. Exhibit 36. Exhibit 30. Exhibit 12, and Exhibit 12 is an affidavit, and 13 is an affidavit. And just excuse me 1 minute, Your Honor.
Sure.
Exhibit 32 is a letter from Johnson to Elking, undated. And Exhibit 33, Your Honor. Those are all letters that we showed to Mr. Elking, and he identified those.
All right. Since this is the actual proffer, I give you an opportunity to object if you wish.
No objection, Your Honor.
All right. The exhibits are all admitted.
Thank you, Your Honor. That's all I have for Mr. Elking.
All right. Sir, you may step down.
If I may, earlier the court inquired about the complaint indictment and jury instructions.
Yes, you have it.
I do, Judge. I have a copy.
If you can approach, please.
Thank you. The complaint indictment remarks states Exhibit M and F. I believe they are also 67 and 70 for petitioner. GG is the jury instructions. I
All
will
right.
get to you now, Judge.
Thank you so very much.
Thank you, Judge.
Oh. The conduct with another instruction. That's what you wanted me to see, right?
Yes, Judge.
All right. You may continue, counsel, with your next witness.
Thank you, Your Honor. We previously discussed this in chambers. The circuit attorney's next witness. Oh, I apologize. Yes, Your Honor. We previously discussed this in chambers, and I just want to flag it. We intend to call Dr. Covera to testify as an expert witness on eyewitness identification procedures and reliability.
Okay, I told you I'll give you an opportunity to lay a foundation. So let's see what you got.
Thank you, Your Honor.
And Judge, if I may, the state would be objecting to calling
The appropriate time to object is after the proffer of a foundation. Then we'll see.
That is correct, Judge. Our objection would be to relevance.
Okay, that also is part of the foundation.
Thank you, Judge.
So we'll see. And then if the foundation doesn't get us there on relevance or the Daubert or anything else, then, you know, then that's the time to object to the testimony. Go ahead.
Thank you, Your Honor. It's my understanding she's on her way.
All right.
Do you solemnly swear that the testimony you're about to give in this cause is the truth, the whole truth, and nothing but the truth to help you God? Please give your name to the court reporter, please.
Margaret Covera, Kovera.
You may inquire, Counselor.
Thank you, Your Honor. Could you please state your name for the record again? I wasn't sure if you did it.
Sure, it's Margaret Covera.
Thank you. Where are you currently employed, Dr. Covera?
I'm a presidential scholar and professor of psychology at John Jay College of Criminal Justice, which is part of the City University of New York.
And how long have you been working there?
I think it's about 18 years now.
Okay. Where are you originally from?
Here, I'm from St. Louis.
Did you grow up here?
Sixth grade through high school, yes.
All right. And then you decided to leave us for New York.
It took me a while to get to New York, but I had a few stops in the Midwest and on the West Coast before I got there.
That's a good segue. Could you please tell the court your educational background, please?
Sure. I got my bachelor's in psychology with departmental honors from Northwestern University, and then I got my PhD in social psychology from the University of Minnesota, Twin Cities.
What year did you get your PhD?
1994.
Could you briefly explain to the court what is the field of social psychology?
Sure. Social psychology is a subset of psychology, which is the scientific study of behavior. And in particular, social psychologists are interested in studying the factors that influence how people think, feel, and behave.
Okay. Do you have a particular field of expertise within social psychology?
I specifically study the intersection of social psychology and law, with an emphasis on legal decision-making and eyewitness identification behavior.
Okay. And when you talk about eyewitness identification behavior, does that include both the eyewitness, him or herself, as well as the procedures used by investigators and police?
Yes.
All right. Do you conduct research into eyewitness identifications?
go into an area not out to the street, but into a big covered area that nobody can shoot into those windows. However, you know, there may be people out here who feel like they need to leave, so I thought I'd better let you know what I was just advised of. So I'll leave that to the people in the audience to make their decisions. Counsel, you may continue.
And I'm not talking about Dr. Gobert. We're comfortable proceeding, notwithstanding the gunshot, Your Honor.
All right.
We just got interrupted.
Same thing from the AG's office? All right.
Your Honor, I think we have a very simple, if you've already made the finding, we certainly aren't going to interfere with that finding, and we will, you know, I would agree that we don't need Dr. Gobert to testify anymore. That being said, if you think that you haven't quite reached the point where you've made that finding, I'm more than happy to proceed quickly with Dr. Gobert and have you cut me off if you'd like.
Let me see if there's any aspect that concerns me. You know, it would have been a better idea if you had asked me to let her listen to his entire testimony, because there's a lot.
Mm-hmm.
I have a whole list of reasons why I have questions concerning the reliability. What say you, the Attorney General's office?
Thank you, Judge. We would object to this witness first regarding relevance. The petitioner has shifted the fact in question. The testimony that you heard from James Elking was regarding that, according to him, officers told him to pick.
Mm-hmm.
If the court believes that, then it's not a question of how suggestive the lineup was. It was an officer telling him who to pick. So there's no fact at issue that this individual would have any relevant information on. Second, Judge, and as the court already pointed out, any testimony from an expert witness has to help the fact finder. Judge, we believe you don't need any help. You are well versed. You have the knowledge and the experience to review what occurred and to come to your own decision. And third, Judge, it sounds like you're going to try to get into particularized testimony regarding an eyewitness. So we would object to particularized testimony, even if the court allows her to testify, as she should be limited to general testimony on general practices and not particular testimony or particular facts in this case. And what I'm trying to get at, Judge, and I'm sure you're aware, she can't say that I reviewed this is specific. And I would direct the court to state the Carpenter, Missouri Supreme Court 2020 case 605, Southwest 3rd, 355.
I think I'm familiar with that case. You have a response to her?
Well, we would agree with that case too, because that was a case in which I believe it was, who was it? I forget which judge. It's Judge Wilson. Judge Wilson wrote it, and he said that eyewitness reliability expert testimony is admissible under Missouri law.
It is admissible, generally speaking.
Yeah.
But you got to understand the word admissible does not mean must be admitted.
Yeah.
A whole bunch of stuff is admissible, but the sound discretion of the court might exclude it for any number of reasons. Now, in this particular case, this witness told me that when it came to those lineup photos, he went back because they basically suggested that the person that they think might have done it was in the picture.
Mm-hmm.
He then picked somebody who, based upon their height and then this whole lazy eye thing,
Mm-hmm.
that he thought might be the person, but he really wasn't sure it was the person. Well, you know, that fits the definition of unreliable in-court ID. He also told me that in court, he ID'd the defendant because it's the only person that looked like a defendant sitting over at the defense table. Now, you don't need a PhD to nail that one down. Right? Although I have a JD, but, you know, not quite the same.
Yes, I think we would definitely agree. The court, I think, is going to see both Mr. Moore.
And I've advised counsel for the Attorney General's office of my view on this, as you heard, as we did briefly in chamber. So I anticipate, number one, she doesn't necessarily have any cross-examination that can go into that. And number two, you know, she no doubt realizes that that's a dead horse that we probably should let lie and move on to the more pertinent issues concerning this case.
And the only thing I would add on to what you just said, Your Honor, is that in that photo array on top of Mr. Johnson was also Mr. Campbell, who actually was the person who was on the steps holding the gun. And
See, I didn't know that until now.
exactly, that was one of the things that we were going to go into.
Yeah.
It wasn't just.
But you should have told me that.
Yeah, here, I'll show you, Your Honor, just so you know.
Which number was Mr. Campbell?
It was the way it was arranged, there actually wasn't.
I'm going to point to the person's Mr. Campbell.
So, Mr. Campbell, right there.
Oh,
You
okay.
see Phil Campbell.
Oh, that's the guy who came in. No, that's not the guy. That's the guy who's dead.
Yes, he's dead, and that was the gentleman who was actually holding the gun on the steps to Mr. Elking.
I got you.
Judge, I apologize, but just for the record, could you clarify what exhibit you're looking at, which picture you're pointing at?
Absolutely. This is Circuit Attorney's Exhibit 62, Your Honor.
And I think you admitted it as Respondents W. And it is the bottom far left photograph with the number 245651 in front of it. All right.
And that's Mr. Campbell.
Okay.
All right. From what you said, with apologies to Dr. Covera.
You cut a check, did you?
Yeah,
Not yet.
I didn't, Your Honor. No.
All right. Good.
We will make sure that she is definitely treated correctly for her crime. So, with
I like
apologies,
that,
Dr.
not
Covera,
yet.
it sounds like.
Thank you, Doctor. I have a quick question for you guys. Did only one person pled guilty, or the two people? Two people pled guilty.
Only one pled guilty, Your Honor, Phil Campbell.
So what now?
He was, remember, the first guy tried was Lamar Johnson. In
Right.
July of '95. Then the next year, in '96, when Mr. Elking stopped cooperating with the police, they made a deal with Mr. Campbell, the guy that he just pointed out to you. He pled guilty to manslaughter and got 7 years.
So we have two people who pled guilty to the crime. Am I correct?
One person, Your Honor.
Oh, one person pled guilty.
There's two people involved.
But only one person is a guilty verdict of any kind.
To a jury, yes, Your Honor.
Well, not necessarily to a jury. Let me make sure I'm clear.
Well,
Judge, may I?
Yes, please.
Yes, absolutely, Judge. So, the state of Missouri tried Lamar Johnson. As the court is well aware, jury found him guilty.
Right.
After that trial, Mr. Philip Campbell took a guilty plea, to which he said he committed the homicide with Lamar Johnson. I will tell the court, if allowed to present evidence and information, we do have that guilty plea transcript.
So the gentleman who testified, I forgot his last name.
James Howard, Your Honor.
Mr. Howard has not pled guilty in this case.
Correct.
Correct.
All right.
His murder is a different case.
All right. Is he going to be charged?
That would be a question for the circuit attorney's office.
Is he going to be charged
It's being reviewed.
with the murder? Is he going to be charged?
It's being reviewed, Your Honor.
After what I just heard, it's being reviewed. Has this person, was that witness ever told anything about the possibility of being charged?
I'm sorry, Your Honor. Can you hear me now?
Speak up, please.
First of all, Your Honor, based on the eyewitness, it's unlikely that we can charge anyone in this case. Based on the testimony.
Hold on, he said he did it. That doesn't take a jury a long time to deliberate on a defendant saying, yeah, I did it. So I just want to know, was that man ever talked to about the possibility of him being charged?
Based on the evidence, Your Honor, I'm still under review of that.
Okay, you're not answering my question. You need to answer it.
Yes, sir.
Was that man ever talked to about the possibility of being charged?
I don't know the answer to the question.
Well, somebody better get the answer to that question, Mr. Weiss. Your case depends on it. So give me an answer. You can call him. Actually, I can call him back. Deputy. Yeah, get that gentleman back in my courtroom at your first opportunity, please. And I'll just ask him directly.
Mr. Howard still here?
He should be. I said he shouldn't be released.
I think.
He should not have been released. Because I was pretty clear about that one. Joseph? All right. Get him here. If he's on the road, tell him to turn the car around and come right back. Because I did not release that man. You may continue.
Thank you, Your Honor. We have another witness. He's out of the courtroom. His name is Tony Box.
All right.
He's a former circuit attorney here. Just worked in the circuit attorney's office. Let me go get him.
I might want to ask this Tony person. Tony Box, did you say?
Anthony Box, B-O-X.
All right. I don't know if I've ever met Attorney Box before. Oh, you're back. I thought we made him mad or something. That's your call. I mean, you and your boss's call, you know. Oh, no, I already knew that. Yeah. Now, if it was like a huge problem, you know. Right. And I'd been right back. Oh, to get pictures. Oh, you're right. I hadn't thought of that. First responders.
Do you solemnly swear that the testimony you're about to give in this call is the truth, the whole truth, and nothing but the truth to help you God? Please give your name to the court and introduce yourself.
Anthony Fox, B.O.X.
Your Honor, can we take about a 10-minute recess?
Nope. You may inquire.
Thank you, Your Honor.
Okay, thank you.
Good morning, Mr. Box.
Good afternoon.
You and I have talked a couple of times on the phone, and this morning was the first time, no, I say take that back. About a year ago or so, maybe earlier this year, we met when you were still in the U.S. Attorney's Office here in St. Louis, right?
Yes, that's correct.
Are you still in the U.S. Attorney's Office?
No, Judge. I moved to private practice.
Oh, okay. Here in town?
No, I moved to Dallas.
I want you to tell us a little bit, the people here in the courtroom, particularly Judge Mason, a little bit about your background. Because when I heard it, I said, I don't think I've ever had a witness with a resume like that.
Objection, is there a question pending?
Yes, there is. How old are you?
That was all right. Didn't ask it that way. Just go from college, law school, first, second, and third job. You know, just let it roll.
Yes, Your Honor. College, I went to Morehouse College in Atlanta. Afterwards, I have a degree in accounting, and afterwards I earned a CPA. After that, I earned a JD from St. Louis University School of Law. After that, I earned a master's in public administration from Harvard Kennedy School. After that, I earned a LLM in tax law from Washington University School of Law.
That's your education.
Yes, ma'am.
How about your work history?
I started out after college in the Army. I was a tank commander. Then I went to the FBI for 9 years. I worked for a CPA firm for a short time. Then I went to the FBI as a special agent for 9 years. And then I left there and worked for a large CPA firm for 3 years. And then I left there and went to Congress. And then I went to war in Iraq. Then I came back and worked for the Department of Defense. And then I came here and worked for the circuit attorney. Then I went to the U.S. Attorney's Office, and now I'm in private practice.
How long you mean the 22nd Judicial Circuit?
Yes, I worked for the...
How long were you here?
18 months, almost 18 months.
She went to St. Louis U Law School, went to Washington U, got a master's here in St. Louis, worked here in St. Louis as an FBI agent for 9 years, worked in the Circuit Attorney's Office here for a year and a half or so, moved over to the U.S. Attorney's Office, and then you're in a private firm called Reed in Dallas.
Yes. I don't even know if I mentioned the U.S. Attorney's Office, but I did. After I left here, yes, I went to the U.S. Attorney's Office.
Are you married, sir?
I am. Been married 27 years, 3 adult sons.
3 daughters?
3 adult sons.
3 adult children?
Yes.
Okay, sir. So,
All of them out of your pocket?
Well, I have 2 in college who are mostly out of my pocket.
Yeah, I could feel you on that.
so you interrupted a conference you're in to come here to testify, right?
I did.
When did you join the Circuit Attorney's Office here in St. Louis?
March 2018.
And what did you do?
Hold on for just a second.
What were you hired to do?
Counsel, hold on for just a
I'm
second.
sorry.
Go ahead.
What were you hired to do?
I was initially hired as the chief investigator.
And what was your job as a chief investigator?
To oversee the team of investigators and their various duties throughout the office in the 22nd Judicial District.
At some point in time, did you get involved in the Lamar Johnson case?
I did when I was working with the Conviction Integrity Unit. I actually took over the Conviction Integrity Unit after Robert Steele left.
You took over.
Hold on, I'm sorry. Were you an ACA or a?
Eventually, actually, when I came on as the chief investigator, I also assumed the role of an ACA, but I didn't prosecute cases until the very end.
I was wondering why I hadn't met you. Go ahead, continue, Counselor.
So you did get involved in the Lamar Johnson case?
I did.
What was your role there?
Well, I shepherded the case once Robert Steele left.
Did you eventually become the lead of the Conviction Integrity Unit?
I did.
While you were looking at the Lamar Johnson case?
I did.
Tell us what you did in connection with looking at the Lamar Johnson case.
I started out by reading the entire file. Quite frankly, I read every scrap of paper I could find on it. The prosecutor's file. There was also information that was put out by the Midwest Innocence Project, so I read that as well. And so I just consumed every piece of information I could find about the case.
Did you interview any witnesses?
Yes, I interviewed Lamar Johnson.
He's the only one you interviewed?
Yes. Well, I also went to a deposition of Elking, Mr. Elking.
When you say went to, that means you observed the deposition, or you actually executed it?
I attended it, no. Lamar's lawyer executed it.
All right.
Lawyer executed the deposition.
So you never had any conversations with Mr. Elking yourself?
I did not.
All right. Did you ever observe any conversations between Mr. Elking and someone from your office other than a deposition question and answer?
No, Your Honor.
All right. Go ahead.
Okay. So after this, did you learn whether or not any payments had been made to Mr. Elking to testify?
I did.
Tell us how you discovered that.
Well, there was information floating about, and information from the file I read and other information from the Midwest Innocence Project that seemed to indicate that there may have been payments made to Mr. Elking. So I went to the victim witness coordinator, who was, at the time her name was Sarah Phillips. Her name is Sarah Phillips, but at the time she was the victim witness coordinator. And I explained the situation to her and told her that, asked her if she could find any information related to payments to Mr. Elkins.
And did she find any information?
She did. She came back within a matter of days and brought me a folder. It was a colored folder, and it was full of information about payments made to Mr. Elkins.
You don't by any chance recall the date of any of those payments to you?
No, Your Honor.
Do you have that folder by any chance, or Photocopies from the
I
folder
have a
he's just
copy.
talking about?
What I have, it doesn't have a date on it, but I think it was roughly January or February of 2019.
January to February of 2019?
Are you asking about the discovery of the documents, Your Honor?
No, I'm talking about when these payments were made.
Oh, no, oh, I'm sorry, Your Honor, I misunderstood. The payment started on November the 4th.
Do you know if
and
that's true or
went
not?
into 1995.
Do you know if that's true, November the 4th?
That's what the documentation that was given to me indicates.
All right. And then what was the end date, sir?
The last, in this summary, I got a date of March 16, 95.
3/16/95.
But what we don't know, Your Honor, is whether that was the last date, because
Well, what we don't know, we don't know. I'm just coming on what I do know.
that's the, on the summary that I have that he's going to identify hopefully shortly, his last payment shows, March 16, 95.
Okay, then that's fine. I want you to go through that foundation. Don't misunderstand me. Silly question, which I should know the answer to, but I don't. What was the date of Mr. Johnson's trial?
July 11 and 12, 1995.
95.
1995. And remember
I'm
this,
sorry, you said July, did you not?
July 11 and 12, 2000.
So then these payments were all executed before the trial.
Before he absolutely, Your Honor, yeah. That's what Elking testified to. Once,
All right, stop right there, and I have one quick question for
Sure.
Mr. Box. Were the existence of these payments brought to the attention of defense counsel before trial? If you know.
Defense counsel, Lamar's, which counsel?
Lamar Johnson's attorneys.
Yes, Your Honor, by me.
No. You came in after the trial, didn't you?
Oh, during the trial, the actual trial. And
In other words, were they brought
No.
to the attention of his defense attorney, Mr. David Bruins, I think was his lead counsel, before July the 11th of 1995?
not that I'm aware. Everything I've read indicates that they were not.
All right. You got to contradict that if you can.
Thank you, Judge, and just for the record, we would object to foundation and hearsay at this time.
Well, he looked over the file. He just testified to me based on his personal recollection. So at this stage, the objection is overruled, but, we'll see how it goes. Go ahead.
we will have two witnesses, Your Honor, that say,
You don't have to give me prediction on your witnesses. I just asked this person. He gave me his answer. You may continue.
so, Mr. Fox, the information that you received, I'm going to hand you Exhibit 16. That is in your book, I believe. and I'll give you
Yes,
a
it is.
copy.
All right. It might be easier if we have a working copy like this. Thank you.
Can you identify that, Mr. Fox?
Yes, this is the information from the folder I received from the victim witness coordinator.
And
Do you
that-
know why this is labeled sunshine request? That the newspaper asked for it as well?
No, Your Honor, the defendant did, Lamar Johnson. He filed a sunshine request.
All right. Keep talking, Counselor. I was just
I'm
curious.
going to send you, and show you next week and mark for Exhibit 123. Your Honor, that's in your book also. This is a letter dated April 26, 2012, from Michael Yu, M-U-E-G, Assistant Circuit Attorney. You seen that, sir?
Yes, I have.
Would you read that to the court, please? I don't have a copy in my hand.
Objection, Judge, lack of foundation and hearsay, he's just having him read the exhibit.
And your objection if the exhibit speaks for itself?
Yes, Judge,
Is there any objection to the exhibit as evidence?
yes, Judge, again, foundation, there's.
He does not recognize this exhibit himself?
So you recognize it, Your Honor.
I do recognize it.
Your foundation goes to,
Judge, my foundation goes to, he didn't work there, he's not an author, of the letter, he didn't receive the letter,
but how could he recognize it if it didn't come up during the course of his actual work?
and Judge, that may be the case, but it's still, no foundation for this specific.
If it came up during the course of his actual work, what does that make it? public record.
Judge, also, I don't believe there's been any testimony, at this time regarding, was this a document kept in the regular course of business, where was it located?
Well, you're right. I didn't get the specificity of that. I kind of put that together, giving the totality of what he has said up until this moment. If you want to ask the trigger question and you can get the right answer, you go right ahead. I'll sustain the objection till the trigger question is asked. Go ahead.
Did you learn that Midwest Innocence Project and others have been requesting information with respect to whether Mr. Elking had been paid for his testimony?
I did. There was requests were made for many years.
Pardon?
I did find out those requests were made for many years.
Requests have been made, and did you find out whether, in fact, they were answered by saying, we don't have any information?
Objection, leading.
If he knows what the answer was that was given, just ask him, do you know what response was given? The official response.
Sure. Do you know what response was given, Mr. Fox?
Yes, we are unable, generally, it was almost invariably, it was we are unable to locate any records. In other words, we do not have any records related to payments.
And are you looking, excuse me, I'm sorry. That letter that you're looking at, is that a letter generated by the office of the Circuit Attorney for 22nd Judicial Circuit?
It is, Your Honor.
Is it a letter that is normally kept in the course and conduct of the business of the Circuit Attorney's office?
It is, Your Honor.
Those are the trigger questions. That's all I was looking for. That's all the Assistant Attorney General was looking for. You may proceed.
Thank you, Your Honor. You did a good job for me. I appreciate it.
Oh, no, you don't.
I do. The exhibit 16 that you have, Mr. Boggs, there's handwritten summaries. Do you know who wrote those handwritten summaries?
I do not know who wrote them.
But they were nevertheless, that was the documents that you found in the files in the Circuit Attorney's office that Mrs. Sarah Phillips gave to you, right?
That is correct.
Mrs. Sarah Phillips was a person that at that time was overseeing the witness protection unit.
Yes, she was the victim witness coordinator.
In addition to the payments, and that summary shows over $4,000, I don't know whether there's other payments or not. Were you familiar with how the witness protection unit works in the Circuit Attorney's office?
Not in great detail, but generally.
Do you know where the money comes from?
Oftentimes it comes from the state.
Could also come from the St. Louis Police Department.
It can.
In addition to finding payments that were being paid to Mr. Elking, did you learn whether or not his parking tickets were being taken care of?
Yes, there was also paper or receipts indicating that his parking was paid for as well.
Did you learn whether or not those parking tickets
I got a question for you, Art. You said parking tickets paid. Now, were they paid or were the charges waived and the tickets dismissed? Or do you know? I wasn't asking you. I was asking
Yes, Your Honor.
Mr. Weiss? Okay, I'll wait till you look up. I was wondering, when you were mentioning parking tickets, were the parking tickets paid from the Crime Victims Compensation Fund, or were they waived by the? So the city councilor was asked to nolly prosecute, because that's the party that would have engaged in such an act.
Yes.
And then they nollied all the tickets. I'm presuming.
Yes.
You tell me if I'm wrong. On behalf of the Circuit Attorney's office.
You heard Mr. Elking say that he had been stopped between the time he was in a witness protection program at the trial, and he told them they were going to take him to jail because they had a lot of outstanding tickets, he was afraid he's going to lose his license. And he said, look, you've got to call Joe Nickerson. I'm a star witness in this case. I don't want to go to jail with the people that have been arrested that were involved in the killing. And they took care of his tickets. And I'm going to show Mr. Box Exhibit 19. And you got it's number 19 in your book here, Ryan. You find that in the file?
Yes, I found this in the prosecutor's file, which was separate from these documents. They were not with these. This was separate.
Actually, I'm give it, Your Honor, I've got a color copy.
And Judge, for the record, what you were being handed contains more information than what is on Exhibit 19. If you would like that marked as an exhibit, the state would have no objection to.
You just want to admit it separately.
Well, I just want it clear for the record that what the court was handed is a little more detailed than Exhibit 19. It's not exact colored copy.
Well, go ahead and tell me what you mean.
So
What way is it materially different?
Well, Exhibit 19, Judge, appears.
Oh,
you can't see the
I
copy.
see.
And what they handed to you is colored and clear for the court, but also has a back.
All right. Well, the only thing that's relevant is what's written down here, I'm assuming. Is that correct? The only thing that's relevant is what's written here. Is anything relevant about the bottom? It looks like it was written on some of the old yellow paper we have over there. Is anything relevant about the bottom of
I don't
this?
think so, Your Honor. I just think this is not like it looked like it was in pink paper.
All right. Well, okay, it's pink. Is there an objection to the pinkiness of the paper?
Not to the pinkness of the paper, Judge,
All right.
But I do have an objection regarding hearsay.
On the bottom part or
No,
the
no, no.
top part?
The entire thing, Judge.
All right, so the objection is hearsay, and your position as being hearsay, because didn't I hear you pulled this from his investigatory records, or did I hear wrong?
These documents were in the circuit attorney's file. Mr. Box has testified, yes,
Right.
that was something he discovered.
Doesn't that get him into the public records exception? Tell me what I'm missing.
Judge, again, I don't recall that foundation being laid. For
Well, I mean, you're right. It wasn't laid with specificity. You are correct in that regard. With public records, you got to go ahead and get out. By the way, was that record something that was kept by the Secretary's office in the normal course and conduct of its business? I see what you're getting at. You want me to dot the I's and cross all the T's, so I will sustain the objection, give Mr. Weiss leave to develop his foundation. Although I am staring at it, so. Problem with a bench trial case.
Mr. Box, do you also remember when you looked in the file in Lamar? Let me ask you this, and I think I forgot to ask you this. These payments history that you looked at, that you discovered, were they in the Lamar Johnson file that you initially looked at?
They were not.
But they were brought separately from the witness protection unit to you, right?
Yes, after I specifically inquired about payments related to this case.
So if someone was looking in the Lamar Johnson file, they would see no record of payments.
No, not at all.
Now, you understand the witness protection office is under the umbrella of the circuit attorney, as I understand how that office works.
I am not educated on that, Your Honor. I believe that the circuit attorney's office has something to do with it. They have full-time employees like Mr. Phillips.
Am I correct or incorrect on that? Is it under the umbrella of the 22nd Circuit Attorney, or is it completely independent from the circuit attorney?
It's under the umbrella of the
Right.
circuit attorney's office.
And then, that being the case, then it's a record of the circuit attorney's office. This person says he got it from an official record of the circuit attorney's office. And I'm having a little trouble with taking care of the hair splitting that I sense in your objection. I'm not sure how there's any real reasonable possibility that the Public Records Foundation cannot be laid if it hasn't already. So I'm going to overrule the hearsay objection on those regards. The relevance is pretty clear, so there's no relevance issue. And obviously no undue prejudice because this goes directly to issues before the court. So, this exhibit's admitted. Proceed.
Did you also learn about letters written between Mr. Dwight Warren, who was the prosecutor in the case, and William Mock, who was the jailhouse informant?
I did.
And they were...
Can I see that white piece of paper right there?
Absolutely, Your Honor.
Just hold it up for a second. It's Exhibit 19. Thank you.
You're welcome, Your Honor.
I'm sorry, I just need to make sure I wrote down the correct exhibit number on this pink slip. All right, go ahead.
Okay, Your Honor?
I'm fine. Please proceed.
I'm going to hand you next what has been marked for identification. This is 99. This is a letter, white mark, to Vicki Myers, Department of Corrections, Board of Probation and Parole, dated June 26, 1995.
What's that exhibit number again? Did you say
This is
99?
99, Your Honor.
All right.
Should be in the book.
Yeah, I'm just going to it.
And Judge, may I see that? Don't believe this one.
Exhibit 99.
Is
I
99
seem to
in
be
the book?
stopping at 97.
There's probably another version of this, Your Honor. Maybe have another number.
You can have this one. I'm quite familiar with it.
99 is the box. I don't see it.
Let me see if we have the number of it. I do want to. We have it in there. No. I've got copies. The judge says it's not in his book.
Yeah, at the top, if you look, it's 97. Then it
97.
jumps up to 114. If you don't mind, I'd appreciate it.
Is that 114 number? No, not yet. I have 99. Yeah.
114 is well, it's something you hadn't gotten to yet.
Okay.
That doesn't have anything to do with, looks like a duplicate of 19, but there's more stuff written on it. So I'm not going to worry about 114 unless and
You have a
until.
copy of 99, Your Honor?
Yeah, I do now. Yes.
I don't believe I have.
That's the next one, yeah.
Mr. Weiss, I'm going to email that to you.
Okay. Box, I'm handing you what has been marked for identification. 99.
I have a copy.
You have. I don't know whether I'm going to have to go through this with you or not, or maybe I don't, but in most of these cases, defense verdict, particularly the public defender's office, sends an office to the prosecutor requesting certain discovery, right?
Yes.
One of the things they would be requesting is any information that you've dealt with the witness, influenced the witness in any way.
Repeat your question about.
Do you remember getting any kind of request where you would have to disclose anything that you did to influence a witness's testimony?
It's broadly phrased, but I received from him the essence of Rule 2503, request, and I gave it to him.
You gave him the information that you had at the time.
Yes, sir.
This is Exhibit 73. It's in your book, Your Honor. You recognize it. That's a request for discovery from David Grimes.
Yes, sir. That would appear to be the prototype of every request from the public defender, or basically from any defense attorney.
And your next one has been marked for identification as Exhibit 76. Also in your book, Your Honor, this is a letter from you, Mr. Grimes, dated December 21, 1984. And you look like you're disclosing some items of discovery, right?
Yes, sir.
But basically what you gave him is 2 police reports.
Yes, sir.
Nothing about relocating Mr. Elking or any payments to Mr. Elking, right?
That is correct.
Okay, sir. I want to talk a little bit about Mr. Bach.
Mr. Who?
Mr. William Mock.
Mock, okay.
William Mock. William Mock was the jailhouse informant that came forward, correct?
Correct.
And you were not aware that he had already come forward in 1992 in a case similar to the type of testimony he gave where he heard somebody in jail confess to a homicide, right? You were not aware of that?
Well, I don't know how similar it was, but yes, I was unaware of any sort of arrangement of testimony for special consideration anywhere else.
And I think you indicated at trial, when you were arguing to the jury, that he really never asked for anything other than a letter to the parole board, right?
I remember something like that in the trial, but I'm not sure exactly how you phrased that question. But I said something like that. He'd never asked for anything other than the letter to the Board of Parole, which I provided to David, and which I wrote to the Board of Parole, and that's all I did.
He started writing letters to you, and you responded to some of them, right?
I don't know that.
You remember him writing letters to you and thought that, where he's telling you he thought his testimony ought to merit a pardon from Governor Carnahan?
I'm not sure what you're just asking.
Do you remember receiving a letter from him where he said he thought his testimony should warrant a pardon from Governor Carnahan at the time?
Well, no, I don't remember receiving any letter, and my response would have been no.
Or that he wrote you a letter and saying he thought that he ought not to be put back in the Department of Corrections, that he ought to be on probation or parole, and ask you if you would recommend that.
I don't remember that, but I never would have recommended probation parole, and I never wrote any letter to Governor Carnahan. Carnahan, did you say?
Hold on for a second. I'm giving you what's been minute as Exhibit 114. You have it there with you already?
Yeah, 114A, this?
Correct. You see the bottom
Yes, sir.
pink, square there?
Yes, sir?
Is that your handwriting in there?
No,
or
sir.
not?
No, sir.
It's not your handwriting, okay. You know what, anybody would write down that they were talking to Cranston Mitchell,
Oh, is
chairman of the Board of Probation and Parole, with a note that he'll be sent
That-
to Ozark Correctional Center for 18 months?
I would
You know why
imagine-
anybody would write that
Oh,
down?
sorry, I thought you were finished.
Go ahead.
I would imagine that might have been a note, not from me, but by Vicky Myers, saying maybe it should be addressed to Cranston Mitchell. But I know that I
Well,
addressed
why
it.
would you have a handwritten note that Vicky Myers would have written, no doubt sitting at her desk in her office in Jefferson City?
I have no idea. You might ask Vicky Myers why it got into my file, but I have no idea. All I can say is that the top part is on what appears to be one of our folders, and it has Judge Mason, not you, a different
I know,
judge,
Donald
Jackson
Jackson
County,
County.
Division 11. That's and Vicky Myers, that's my handwriting.
Okay.
I had to know where to send the letter,
Mhm.
and I ended up sending it to Vicky Myers.
Can you next with an Rockford application, this is This is a letter, Mr. Warren, where it says, Dear Mr. Wright, W-R-I-G-H-T, and it is from William Philip Mott, dated June 1, 1995. That's 160. That's before the trial, right?
It would appear 6/1/95 is the date of this.
Hold for just a moment. Did you not, in laying the foundation for 114, did you tell me that this handwritten portion was on the back side? This is the front and back of the same piece
I
of
think
paper?
so, Your Honor.
How did you arrive at the conclusion this is the front and back of the same piece of paper? Is that how you photocopied it? Who, somebody, I heard that being spoken.
That's part of our objections from earlier, is we don't know anything about where this stuff is from, so we can't answer those questions.
No, Your Honor, Mr. Goodwin's mistaken. When the Attorney General's office came in, that slip was among the circuit attorney's records that was available for them to photocopy. And I don't know specifically about how that was photocopied like that, but I can say that that's in the records.
That's correct, Your Honor. I agree with Mr. Potts. Whenever we reviewed the file in the circuit attorney's office, that piece of paper was there, and Mr. Potts and I both requested that a front and back copy be made,
So this is the front and back of the same piece of paper.
that is my recollection.
Let's return to Exhibit 114, Mr. Warren.
Oh, 114, okay. 114A.
Now, you've already told us that some of your handwriting appears on, I will call it the front side, the top part of this piece of paper.
I have
And all of this information concerning Cranston Mitchell appears on the back side of that exact same piece of paper. You have an explanation for me?
No, sir.
All right. Go ahead.
Exhibit 160.
Hold on, I think you wanted me to review 160. I'm still reviewing it.
So, he apparently is, you remember getting this letter?
Not really, but I could have.
He says, per our conversation today with yourself and John, I felt the need to put my intentions in writing. Who would John be?
I don't know, unless it was my investigator, John Moss, the same person to whom I gave his pedigree to run his record. That's the only possible John that I can think of.
He goes on to say, I will testify articulately, accurately, and honestly to the information I acquired while at the city holdover, bringing about a successful resolution of this trial. I don't believe that anyone in the legal system will disagree with the value of my testimony in this trial as opposed to this conviction I am now serving. I'm willing to testify so long as I don't have to return to the Department of Corrections once I testify. I won't live in protective custody or any institution once I testify. Do you remember talking to him about that?
No, sir. This is Mr. Mock talking. It's not me. It's not my response to him. I would not concur with what he was suggesting.
Okay. He says, I'm serving a 5-year sentence for CCW, or CCLU, I can't read it, which I now have been serving since early '93. I feel my testimony is worth a pardon by Mr. Carnahan, or a reduction in my sentence by Judge Mason, Division 11 of the Jackson County Court, Kansas City, Missouri. Cranston Mitchell, the head of probation and parole, can only parole me. And he and his agents can also violate my parole and return me straight back here for next to nothing. I can't take that chance. These young blacks.
What was that last part? Where are you?
I'm reading at the bottom of the page.
Okay.
Are too tight knit in this prison system. Of course, I don't plan to violate my parole, but it's easy to wind up right back here for next to nothing. If that were the case, the blacks would know I testified before I was returned to prison. That will not happen. I propose this, that Judge Mason reduce my 5-year sentence to time served with something I can't read of for my testimony, or that Governor Carnahan pardon me with time served, thus guaranteeing my safety away from the Department of Corrections. Thus, if I return to the MDC it will be my own
You need more water?
closing.
I do need some more water.
Yeah. Can somebody get him some water?
Thank you. Ah, bless you. That's right. Thank you.
You recall having conversations with him where you told him, I cannot get you a pardon from Judge Carnahan. I cannot guarantee you won't go back to the Department of Corrections.
If I had a telephone conversation, number one, it would have had to have been initiated by Mr. Mock. I had no way of phoning wherever he was confined and talking to him. That's number one. Number two, this is his desire. I'm not going to do it, period. If I buy testimony, I've got to reveal it to the defense, and that just weakens my case. So I'm not going to buy his testimony, no matter whether he thinks it's earned or not. He can dream on.
I gather you don't recall turning these letters over to Mr. Bruns prior to trial.
I don't, and I don't know that I would have. Who said that?
Well, I'm hoping nobody was commenting on the witness over there, so I'll just let it go. Go ahead. You okay with coming back in the morning if necessary? It's kind of going to be
Okay, but
necessary.
not looking forward to it.
10 to 5.
You got it.
I'm sorry, continue, Counsel.
Oh, okay. Do you remember after trial, after the conviction? Let's set this up. So there was a 2-day trial, right? About?
I suppose, at least.
Okay.
You know, a day for voir dire at least, and then I'm known for my brevity. I probably would have put the case on in one day.
So Mr. Bruns filed a motion for new trial within the time required by the rule, right?
I would assume so.
And do you recall in that motion learning about the fact that Campbell, Phil Campbell, the other person arrested, had written letters to Lamar Johnson while Lamar was in trial? Remember that?
I remember at some point, I was told that Phil Campbell had written a letter to Lamar, and I notified the police department. They secured a search warrant and I think seized letters from, I think they were in Lamar's possession.
Yeah. So this exhibit is part of one of the police records. There's a thick one that the whole lot sits in it. But I've numbered this 44A. And this is a supplemental incident report of Lamar Johnson. And I've flagged a couple of pages. And page is 1, primarily.
Do you have the report number on it? I can find it.
I don't see the 44A.
I don't think it's in your book. You know, it's part of a large packet of police reports.
Oh, I just need to get what you're discussing with this witness. It's all you have to give me.
So this is on page 3. I just want to give you this to make sure. It says, Attorney, on Thursday, September 14, 1995, homicide detective Thomas Toretta, DSM 16.
Your Honor, I'm objecting to just reading off the report. You can properly
Yeah.
the report I have.
Do you in a case like this, right? I mean, if you want to challenge, you know, like it's a fake document, Your Honor, it has nothing to do with the cases, or unduly prejudicial, that kind of thing, that's fine. I understand the objection. We're in front of a jury. I might pay a little more attention to it. But I can pretty much parse these matters myself. Is this some sort of fake document that you think it's untrue, that I shouldn't even consider it?
No, Your Honor.
All right, then go ahead, Counselor.
Mr. Warren?
You can call me twice.
Deputy Swanson. Page 1.
And your question is what?
Is that refresh your recollection, if you need to, that there was an incident that shortly after trial, I mean within a few days after trial, a motion for new trial is filed. You learn about that, and there's mention in that new trial motion about letters to Lamar in which Phil Campbell is basically admitting he was involved in the murder. Phil Campbell still has to be tried, remember? And you were assigned his case, right?
Yes. I'm still not puzzled as where you're going.
So I asked, did you instruct the police department, did you get a search warrant? Did you institute getting a search warrant for the police to go over and search Lamar Johnson's cell?
Maybe I was reading this and tuned out. Did I initiate the police getting a search warrant? Yeah, I told them that they had to get a search warrant for the letters. If that's what you're asking, the answer is yes.
In fact, photographs were taken of the search of that trial, of that case, of his cell, right?
Well, they may have. I don't know. I don't know that I ever saw them.
Okay.
Remember, this is after the trial.
This is shortly after the trial. Yes. Sir.
Yeah. Well, I don't know that I ever saw them.
I'm going to show you Exhibit 55. Can you identify the person in that picture?
Going back 30 years ago, but that looks like Tom Toretta.
Tom Toretta? He was in the police department?
Yes, and you can date it because of the beeper on him.
Yeah.
You recall asking that pictures be taken?
Do I recall seeing this picture?
Yeah.
No, I don't recall it. I'm not saying I didn't, but I don't recall seeing it.
Okay, there were a number of pictures taken, actually.
Well, same response on all of them.
Yeah. Remember receiving copies of that, which looks like Lamar Johnson.
What is this yellow and black thing?
I don't know.
Is that a shiv?
Oh, the yellow thing, that's just a fold-up piece of
That's a piece of paper.
envelope. Yeah, that's just an envelope.
Oh, well, no wonder.
The only question I have is how would he know if this was Lamar Jackson's cell?
Because he issued the asked that they go over and search his son.
You're walking away. I can't hear you, sir.
Because they went over and asked that his cell be searched.
I asked what?
That his cell be searched.
Hold on, let me shortcut this. Do you see Exhibit 57?
Yes, sir, I do.
Was
I had
this-
it upside down.
Was this sent back to you by the Department of Corrections with a notation that this was the cell of Lamar Johnson?
I think
He's in the city jail at this time, Your Honor.
Was this sent back to you by the city jail
No,
with any statement that this was the cell of Lamar Johnson?
was what?
That this was the cell of Lamar Johnson?
No, sir.
You have any idea whose cell this is?
I would suspect it to Lamar Johnson's because that was who I was told wrote the letter,
Mhm.
and that's who I suggested that they get a search warrant for the letters in Lamar Johnson's cell. So I assume that that's his cell.
Well, let's operate then on the assumptions that it's the right cell. But when you talk about foundation photographs, somebody has to say, oh yeah, that's it, and it's a fair and accurate copy, and I know what it looks like, and that's it. And you don't have that. So go with what you got, but I'll only take it for the weight that I can give it under these
I
circumstances.
appreciate that, Your Honor. And actually, it's just leading up to the next series of questions. Did they bring back to you the letters that they found in Lamar's cell that Phil Campbell had written to Lamar?
I have a vague recollection of having seen that, but I cannot swear.
Let's look at it, and I'm going to hand you Exhibit 2.
Okay. Like I said, it vaguely sounds familiar.
So, can you tell us now, sitting here, that these are copies of the letters that you received from the search that you had directed of Lamar Johnson's cell?
No, I can't say for sure, but I wouldn't say I didn't.
You remember, sir, at the hearing on the motion for the trial, you were there?
No, I don't know. Was I? When was the date?
You remember that?
When was the date?
These are part of the record before you. Mr. Brown says, just for the record, I take it we are stipulating that these letters were written by Phil Campbell. Mr. Warren, for the purpose of this hearing, I would be more happy if Phil Campbell wanted to stipulate that they are in fact his letters. For the purpose of this sentencing, I'm willing to agree that they are written by Phil Campbell. So, I'm showing you on the chart one of these exhibits, and it's signed by Phil. Do you know who Phil is?
I assume that you want me to say that that's Philip Campbell, and I suppose it is, but I don't know that.
Says, what's up, dude? That's effed up. You got convicted when you didn't do a thing. Told my lawyer to let me tell the truth, but he won't, because he said I could get
I could beat my case.
I could beat my case. I'm sorry, I got you in this, but me and didn't try and kill Marcus. It just happened. That white boy ran when I pulled him from the steps. I didn't see him anymore after we shot Marcus. Those people told him to lie on you. Keep your faith in God, because He will make everything all right. I told you to get a lawyer because the PD be working for them. I hope you get approval. Stay up. I don't know what that means.
That says, I hope you get appeal.
Okay.
You get appeal. I know it's.
Thank you, Your Honor.
Yeah.
I'm not quite there yet on that.
That's okay. I just have a question. Do you have any idea as to when that note was written?
Those were written between his conviction and I think when that search warrant is in this report.
Somewhere between Johnson's conviction and when the search warrant was executed.
And that was, I think, the search warrant might have been September. It's in that report.
Your Honor, I would just say for the court that whenever the record for the motion for new trial and on appeal, they didn't consider the letters because they couldn't find any date, and because they couldn't be authenticated by a date, that's why they weren't considered on.
Yeah, but I have a little bit more. You may not know what I have in front of me, but I see a file stamp date here. Although this is kind of down the line, though, because I have September the 28th, 1998 on my file stamp here.
So that's why they were introduced in another proceeding subsequently, Your Honor?
Yeah, they were introducing something because they were file stamped.
Well, I think this might clear it up, Your Honor. It says,
Oh, hold it out. The file stamp ink is a little better here. It says September 29th, 1995. So that actually is what the file stamp date is. And
this police report says Attorney Warren provided that on August 4th, 1995, Lamar J. through his attorney, David Johnson, filed a motion for new trial. And then they went over it and they said,
these are most likely attachments to the motion then, to have that file date on them.
Not attached to the motion, but they were seized by September 14th, 1995. So it was fairly shortly after the conviction. They were both in jail.
That would be a logical conclusion.
They were both in jail together at that time.
Mm-hmm.
And Your Honor, just to clarify again, I believe on the direct appeal, which the record is stipulated to being accurate for the court's consideration, I believe on direct appeal there was some sort of evidence that it's possible, and the Court of Appeals could not ascertain that those letters had been received by Mr. Johnson prior to the trial date, and because that could not be clarified, that is why they went into.
I wasn't concerned about prior to the trial date.
Okay, I just want to make sure the record is clear, Your Honor.
Right. In fact, I was concerned as to how soon after the trial date these were likely to have been written. And I have my answer.
When you got these letters, did you read them?
If I got them, I would have read them, yes.
Did you use them in connection with the motion for new trial?
I don't believe I would have.
Do you remember that?
And again, the record of that proceeding will speak for itself.
Do you remember that? Well, let's look at this, another one of these letters. Lamar, I don't know why you keep telling people we tried to kill Marcus. Went up there to pistol whip Marcus about talking shit to Puffer. When we ran down out the gangway, B.A. tried to grab Marcus. They started wrestling with a gun, and that's why we had to shoot him. I don't know that monkey lied to us having on mask. One of the reasons why B.A. put one on is because Marcus knew he stayed down the street, and he might tell what he would have did to him. Nobody did point no gun at that honky officer after we shot Marcus. When I turned back around, he was gone. So we ran back to B.A. house. I know you was your homie, but you know how the game goes. What Marcus had took. But B.A. I can't read the DA something, and shot us. Do you dig what I'm saying? Just be cool and stop.
It's not the great English, the BA gone and shot it,
Yeah.
is what it says.
Thank you, Your Honor. Just be cool and stop telling people bullshit, all right? Much love and stay. Now, those letters were introduced at the hearing on the motion for new trial, right?
I don't know if they were, okay. When was the motion for new trial? I asked that again.
And the motion for new, they were introduced at the motion for new trial.
When was that, is my question.
Well-
Because I was on active duty starting sometime in December.
I think you were there.
That's what I'm trying to figure out.
Yeah, I think that was before you went on active duty, which was what, after the first of the year?
If that's so, then that's fine.
Okay.
I just don't
Hold
know.
on for just a moment. Yourself approach me, please. I'm going to have to recess this until the morning.
Okay, Your Honor.
You can leave all your stuff here. We're going to secure the courtroom. I know you want to take your camera, but leave your tripod. That's fine. You can leave all these exhibits and the like, because the room will be secured. But I will see all of you tomorrow morning, 10 a.m. Sound good?
Sounds good, Your Honor.
All right.
Thank you very much.
All right.